In this video, we will begin our look at the buyer's remedies where the seller breaches by making a non-conforming tender of goods that the buyer chooses to accept, by focusing first on how the buyer may go about accepting the seller's tender of goods. So what constitutes an acceptance of the goods by the buyer? Remember, as we noted before, acceptance is the opposite of rejection, and with respect to each commercial unit that the seller has tendered, the buyer must either accept or reject the seller's tender. The buyer must do one or the other, and the buyer cannot do both. So it is helpful in considering what constitutes an acceptance to compare acceptance to rejection, the topic from last week's module. Let's review for a moment. Press pause now and think about it. What does the buyer need to do in order to make an effective rejection of the goods? Remember, under Section 602, subsection 1, in order to make an effective rejection, the buyer must reject within a reasonable period of time by giving the seller seasonable notice of rejection. Remember also, as we previously noted, a buyer may make an effective rejection even if the buyer has no right to reject the seller's tender. Where the seller makes a conforming tender and the buyer rejects that tender, then that puts the buyer in breach, a scenario that we will take up in the next week's module. So, with the requirements of an effective rejection in mind, how does the buyer go about doing the opposite? How does the buyer accept the seller's tender of goods? Section 606, subsection 1, defines the circumstances under which the buyer accepts the seller's goods, and in particular, it defines three ways that the buyer may accept. First, after a reasonable time to inspect the goods, the buyer signals to the seller that the buyer is accepting the goods. Note here the similarity between this form of acceptance by the buyer and rejection by the buyer. In both circumstances, within a reasonable time after the seller's tender or delivery of the goods, the buyer tells the seller that as the buyer manifests the buyer's intent as to whether she is accepting or rejecting. A second way the buyer may accept the goods is that after a reasonable time to inspect, the buyer simply fails to make an effective rejection. Stated differently, silence or inaction on the part of the buyer after the seller's tender constitutes an acceptance by the buyer of the seller's goods. Likewise, failure by the buyer to give timely notice of rejection to the seller constitutes an acceptance by the buyer of the seller's goods. So if after a reasonable opportunity to inspect the goods, stated differently, after a reasonable time after the seller's tender or delivery of the goods, the buyer fails to effectively reject the goods, the buyer defaults into accepting. Finally, the buyer may accept the seller's goods at any point in time if the buyer takes any action inconsistent with the seller's continued ownership of the goods. So any use, consumption, or destruction of the goods by the buyer, any resale of the goods by the buyer, any of these things constitutes the buyer's acceptance of the goods. Here again, it is important to remember that under Section 513, subsection 1 of Article 2, before accepting, the buyer has a right to reasonable inspection of the goods. So if the buyer's use of the goods is reasonable and necessary to determine whether the goods are conforming, that use is not considered acceptance, even though such use might otherwise be considered inconsistent with the seller's continued ownership of the goods. That use is instead considered consistent with the buyer's right to inspect the goods under 513 of Article 2. Two important points to emphasize here. Unlike rejection, a buyer can inadvertently or unintentionally wind up accepting the seller's goods. That is because rejection requires an intentional, purposeful act on the part of the buyer. The only way the buyer rejects is for the buyer to give the seller notice of the buyer's rejection. By contrast, a mere oversight by the buyer, either by doing nothing and failing to reject within a reasonable time, or by doing something to the goods that is inconsistent with the seller's continued ownership of the goods, will constitute an acceptance of the goods by the buyer, even if the buyer did not subjectively understand that through her conduct she was accepting the goods. The second important point to note is what is not considered an acceptance by the buyer, what is not listed as acceptance under 606 subsection 1. First, the buyer is simply taking possession of the goods. As we have said before, buyer taking possession of the goods might be necessary to facilitate the buyer's inspection of the goods. The buyer's taking possession of the goods is not the same thing as accepting the goods. Indeed, it may be impossible for the buyer to exercise its right to inspection of the goods for conformity without first taking possession of the goods. The two are totally separate and unrelated, so don't confuse the buyer's possession of the goods with the buyer's acceptance of the goods. Second, buyers paying for the goods is not considered an acceptance by the buyer. Paying for the goods is not listed as a form of acceptance under 606 subsection 1. Recall that we said the default rule under Article 2 is that payment is due when the goods are accepted by the buyer, after the buyer has had an opportunity to inspect the goods. But the parties may in their contract agree that the buyer must pay the seller in advance before the buyer has had the opportunity to inspect the goods. If the parties' agreement requires the buyer to prepay for the goods, then under Section 512 of Article 2, the buyer's payment to the seller is not an acceptance. Even if the buyer has already paid the seller for the goods before they are tendered to the buyer still has a right to inspect the goods. And upon inspection, the buyer still has a right to reject nonconforming goods. The simple difference here is that if upon inspection the buyer wants to reject the goods because the buyer has already paid the seller for the rejected goods, instead of withholding payment for those goods, the buyer must instead seek a refund from the seller for the amounts that the buyer has already prepaid to the seller. But the important point to note for the present purposes is that the buyer's payment for goods may be totally separate and unrelated to the buyer's acceptance, particularly where the party's contract requires the buyer to pay the seller before the seller's tender and the buyer's inspection of the goods. So, as with possession, don't confuse the buyer's payment for the goods as the buyer's acceptance of the goods. So, what are the consequences of accepting nonconforming goods? Here again, it is useful to compare the consequences of acceptance with those of rejection. So let's review again. Press pause now and think about it. What are the buyer's rights, obligations, and remedies upon making an effective and rightful rejection of goods? Remember, the general obligation of a rejecting buyer is described in Section 602, subsection 2b. The buyer has an obligation to take reasonable care of the rejected goods, reasonable care for a reasonable period of time to allow the seller to remove them. And merchant buyers are further required to follow any reasonable instructions of the seller as to the rejected goods. In addition, the rights and remedies of a rejecting buyer are described under Section 711, subsection 1 of Article 2. Upon rightful and effective rejection, the buyer may cancel the contract. That means the buyer need not make any further payments that would otherwise be due to the seller for the rejected goods. Stated differently, the buyer's obligation to pay is discharged and excused. And in addition to cancellation, if the buyer has already paid the seller in full or in part for the rejected goods, the buyer is entitled to recover that amount. And finally, the buyer is entitled to recover damages from the seller, either cover or market-based damages pursuant to Sections 712 and 713 of Article 2. Now let's compare that to the buyer's rights, obligations, and remedies upon accepting a non-conforming tender of goods. Those are primarily set forth in Section 607 of Article 2. 607 includes three relevant subsections, 1, 2, and 3. Let's start with subsection 2 first. Subsection 2 states that once the goods have been accepted by the buyer is generally precluded from later rejecting those goods. We must say generally, though, because as we will later see in this module, under very limited circumstances, the buyer may have the right to revoke an earlier acceptance of non-conforming goods. But the general rule is that upon acceptance, the buyer is precluded from then rejecting the goods. That means that all of the rights and remedies associated with rejected goods are now off the table. That includes the cover remedy under 712, the market-based damages remedy under 713, even the right and process of cure by the seller under Section 508. All these provisions become inapplicable upon the buyer's acceptance of the goods. Note, there is no similar rule regarding rejection. A buyer may reject but then later accept a non-conforming tender of goods. If after initial rejection, the buyer changes her mind, or the buyer takes any actions inconsistent with the seller's continued ownership of the goods, it's possible to convert a rejection into a subsequent acceptance. But in contrast to rejection, acceptance is final. Once accepted, as a general matter, the buyer cannot later reject accepted goods. Again, we must say generally, though, because as we will see later in this module, under very limited circumstances, the buyer may indeed revoke an earlier acceptance of non-conforming goods. Moving on from subsection 2, subsection 1 says that upon acceptance, the buyer must pay the seller the contract price for the goods. So unlike a rejecting buyer, an accepting buyer cannot cancel the contract and refuse to pay. The accepting buyer is still obligated to perform its obligations under the contract. The obligation of the buyer to pay the seller is not discharged and excused. But the buyer's acceptance of the seller's non-conforming tender is not a waiver by the buyer of the seller's breach. That is, even though the buyer cannot cancel the contract, even though the buyer must pay, when the buyer accepts non-conforming goods, the buyer has not realized the full benefit of her bargain with the seller. After all, the buyer is getting from the seller something different than what the parties had contracted for. So the accepting buyer retains the right to seek remedies against the seller for the seller's breach. But subsection 3A imposes an important limitation on the buyer's right to seek remedies against the seller. The accepting buyer must notify the seller of the seller's breach within a reasonable time after the buyer discovers or should have discovered any nonconformity in the seller's tender or goods. Otherwise, the buyer is barred from any remedy. Assuming the buyer gives timely notice under subsection 3A, the buyer's remedy is set forth in section 714 of Article 2. As we will see in the next video, that remedy is almost always damages, but the measure of the buyer's damages in this case is different than the cover or market-based damages that we have previously looked at. Now let's unpack these last two items. For the remainder of this video, we will look at the buyer's notice to the seller of breach. And in the next video, we will address the damages available to the buyer who accepts a nonconforming tender. As we have noted, a buyer electing to accept nonconforming goods does not waive the buyer's rights arising from the seller's breach. The accepting buyer retains a right to a remedy against the seller provided the buyer provides the seller notice of the breach. If the buyer fails to give notice, the buyer is barred from seeking a remedy. As such, the consequences for the buyer by not providing adequate notice to the seller are rather draconian. The buyer loses the right to sue the seller for the seller's breach. To avoid this harsh result, courts tend to apply this notice requirement fairly leniently. As to the timing of the buyer's notice, subsection 3A requires the notice be made within a reasonable time after the buyer discovers or should have discovered any nonconformity, not within a reasonable time after the seller's tender or delivery of the goods. Instead, within a reasonable time after the goods are tendered or delivered by the seller, the buyer has a reasonable opportunity to inspect the goods to discover any nonconformity. Then, under subsection 3A, the buyer is allowed a further reasonable time to give seller notice of rejection. Stated differently, the buyer is afforded a reasonable time to inspect, and then upon completing inspection, an additional reasonable time to provide the seller any notice of breach. So the deadline for the accepting buyer to give notice of breach is quite forgiving. Likewise, as to the contents of the buyer's notice, what is required under subsection 3A is quite different than what is required in the buyer's notice where the buyer is rejecting a nonconforming tender. Recall that under section 605, if the buyer rejects the seller's nonconforming tender, but the buyer, in its notice of rejection, fails to identify a particular defect, and that defect was ascertainable by a reasonable inspection, and seller could have cured the defect had the buyer's notice made the seller aware of it, then the buyer's rejection on the basis of the undisclosed defect is unjustified and wrongful. In contrast to a rejecting buyer, if the buyer accepts nonconforming goods, then there is no similar requirement that the buyer's notice to the seller identify the particular defects. The rationale is that, unlike in the case of rejection by buyer, where the seller may have had the opportunity to cure its breach if it was made aware of the particular defect upon which the buyer was rejecting, in the case of acceptance by the buyer, the seller has no right or opportunity to cure. So there is less need for the buyer to provide notice to make the seller aware of any defects or nonconformities. Instead, where the buyer accepts the seller's nonconforming tender of goods, the buyer's notice under subsection 3A must simply inform the seller that the buyer believes the seller is in breach. Official Comment 4 to section 607 elaborates on this point, that the content of the notice need merely be sufficient to let the seller know that the transaction is still troublesome and must be watched. There is no reason to require that the notification which saves the buyer's rights under this section must include a clear statement of all the objections that will be relied upon by the buyer as under the section covering statements of defects upon rejection. The notification which saves the buyer's rights under this article need only be such as informs the seller that the transaction is claimed to involve a breach and thus opens the way for normal settlement through negotiation. So all that is required of the buyer's notice is to simply put the seller on notice, so the seller can investigate the buyer's claim, prepare for potential litigation, or initiate negotiations with the buyer in pursuit of a settlement. So in this video, we examined first what constitutes an acceptance of the goods by the buyer, and then what are the consequences of the buyer's acceptance? What are the parties' respective rights, obligations, and remedies? Contrasting those rights, obligations, and remedies to the situation where the buyer rejects the seller's nonconforming tender. In the next video, we will look more closely at the buyer's damages where she elects to accept a non-conforming tender by the seller.